Be seated, please. Would the defense call its next witness?
Your Honor, the defense announced rest at this time.
Very well. Members of the jury, both the state and defendant have rested their cases. This means that you've heard all and received all of the testimony and evidence pertaining to this case. The attorneys will now present their final arguments. Please listen to what the attorneys say, and remember, it is not evidence, but you should listen carefully to their arguments. In making their arguments, the attorneys will be referring to the evidence presented or not presented during the trial. The attorneys will not intentionally misrepresent the evidence. Rather, they'll be relying upon their recollection of what the evidence was. Your recollection of the evidence may differ from that of the attorneys, and in that event, you should rely upon your own recollection of the evidence. These arguments are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has spoken. State ready to proceed?
Yes, Your Honor.
Please do.
May it please the court, counsel. Good afternoon, everyone. I know it's been a long week. I appreciate your attention. The defendant in this case, as you know, has been charged with 3 different offenses, crimes. First one was aggravated manslaughter of a child. Second one was third-degree murder, not premeditated during a felony. And the third one was leaving a child unattended or unsupervised in a motor vehicle with great bodily harm, or as in this case, death. I want to go through these counts in a little bit of detail, and there are lesser included offenses as well, so I want to go through that. The state, in order to prove aggravated manslaughter of a child, has to show 3 things. One, that Ariya Paige, the victim in this case, the 10-month-old infant, is unfortunately deceased. She is dead. We have proven that. Number 2, the death of Ariya Paige was caused by the culpable negligence of the defendant, who is seated in the courtroom today. I want to tell you, the court's going to tell you later during the jury instructions what is culpable negligence. The judge is going to read to you a bunch of instructions, but I want to tell you just a small portion of it. Culpable negligence means that every person has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. The important thing here is if there's a violation of a duty to be a nanny, a duty to be a babysitter, even if you don't have a conscious intention to harm somebody, then it is culpable negligence. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm to the victim, in this case being Ariya Paige. And the state has proven that the defendant engaged in a course of conduct by leaving the baby in the car for a little bit over 5 hours. That is, it is reasonable to expect that the baby would die. Another thing I want to say about neglect. Neglect can be based on repeated conduct, meaning it happens many times, or on a single incident like this one, or omission by a caregiver. The defendant admitted on the stand she was a caregiver. Omission by a caregiver that results in or could reasonably be expected to result in serious physical injury or in this case, death. That's what we have here. This is aggravated manslaughter of a child. The state has proven all three elements. But there are some lesser elements, offenses, I should say. And I'm going to go through these. The state feels that you should find the defendant guilty of aggravated manslaughter of a child. But the first lesser is manslaughter. This is the difference between manslaughter and aggravated manslaughter. Manslaughter, I need to show two things. One of them is Ariya is dead. Obviously, we've proven that. Unfortunately, she is deceased. Two, the death of Ariya was caused by the culpable negligence of the defendant. Once again, we proved that. That's all I need to prove. The difference, aggravated manslaughter has a third element that we proved, that Ariya was a child at that time. She was only 10 months old. Brooke and Justice both took the stand. They told you what her date of birth was. They told you she was 10 months old in July of 2023. Paul Dickinson, the EMS paramedic, took the stand and said he determined she was 10 months old. Dr. Aaron Ward took the stand. He said she was 10 months old. Dr. Thomas Coyne, the medical examiner, said he determined she was 10 months old. The state has proven she's a child. So there's no doubt of that. Also, for this to be aggravated manslaughter of a child, the state has to show a caregiver. That's the key word, a caregiver, that the defendant was a caregiver for Ariya, and we have shown that. So the state is saying to find her guilty of aggravated manslaughter of a child. We have met all three elements. The regular manslaughter doesn't really involve a child. Then we go to another lesser included offense that you have a choice of. Once again, the state is not asking you to find her guilty of this one. We want you to find her guilty of aggravated manslaughter of a child. The next one is called neglect of a child with great bodily harm, permanent disability, or permanent disability. This is what I would need to show. Number one, the defendant, by culpable negligence, failed or omitted to provide Ariya with care, supervision, and services necessary to maintain her physical or mental health. Two, that the defendant caused great bodily harm to Ariya. Three, she was a caregiver. Four, that Ariya was under the age of 18. Well, there's one thing missing here. I don't need to prove that Ariya is deceased or that she's dead in this one. That's why the state is saying, no, we want aggravated manslaughter of a child. Ariya is dead. That's the proper one to find her guilty of. But there's still 2 or 3 more lesser offenses that you can choose from. Another one is called neglect of a child without great bodily harm. That one, we have to show once again that the defendant, by culpable negligence, failed or omitted to provide Ariya with care and supervision, that the defendant was a caregiver, and that Ariya was under the age of 18. This one, once again, says without great bodily harm. No, Ariya is dead. We go back to the aggravated manslaughter of a child. That is the proper one to find the defendant guilty of. Then we have 2 more left. Culpable negligence, inflicting injury. I would have to prove 2 things here. The defendant inflicted actual personal injury on Ariya, and she did through, once again, culpable negligence. In this one, the state would not even have to prove that Ariya is a child. Obviously, we prove she's a child. We go back to the aggravated manslaughter of a child. That's what we want you to find her guilty of. And the very last one is just culpable negligence, exposing a child to injury. No, Ariya wasn't just exposed. Ariya died because of this. So in the end, with aggravated manslaughter of a child, and you'll see on the verdict form that there are all these lessers, the state is asking you to find her guilty of the very first one, aggravated manslaughter of a child. Now there's 2 more counts that I want to go through. But I want to go do it a little bit backwards. Rather than doing count 2 and then count 3, I'm going to go to count 3, and I'll explain why in a second. Count 3 is leaving a child unattended or unsupervised in a motor vehicle with great bodily harm, or in this case, death. This is what the state needs to prove. The defendant was a person responsible for Ariya. State has proven that. Ariya was under the age of 6 years old. Once again, the state proved that she was 10 months old. The defendant left Ariya unattended or unsupervised in a motor vehicle for a period of in excess of 15 minutes. Think about this for a minute. All the state needs to show you is she left her in the vehicle for over 15 minutes. This defendant left Ariya in the vehicle 20 times more than that. 15 minutes is all I need to prove. She left her for a little over 5 hours. And lastly, what I need to show is that in so doing, Rhonda Jewell, the defendant, caused great bodily harm, permanent disability, or permanent disfigurement to the child, Ariya. Obviously, she did, because Ariya is deceased because of this. We are asking you to find her guilty, the defendant, of leaving the child unattended or unsupervised in a motor vehicle which resulted in great bodily harm, as in this case, Ariya is deceased. There's only one lesser, and basically what that one says is that the defendant left Ariya in a vehicle, that the child was under the age of 6, it was over 15 minutes, but there's no injury. That is not one that you would check off. It would have to be leaving a child unsupervised, resulting in great bodily harm or death. Now I want to go to count 2. Count 2 and 3 are linked in that the crimes charged in count 3, which I just mentioned to you, leaving a child unattended in a motor vehicle, is an element of count 2. Count 2 is a third-degree murder charge. This is what the state needs to prove for count 2, third-degree murder, third-degree felony murder. It's unpremeditated. We're not saying that any of this is premeditated. We're saying this is not premeditated. Number 1, Ariya is dead. We've proven that. Number 2, and this is the important part where count 3 comes into it. While engaged in the commission of leaving a child unattended or unsupervised in a motor vehicle with great bodily injury, the defendant caused the death of Ariya. You remember the example I gave, I think it was on Monday. I talked about if someone committed a felony, if someone robbed a bank, they had no intention of hurting someone. They wanted to rob the bank, and during the course of that robbery, unfortunately, somebody died. It's felony murder. What we're saying is the defendant in this case committed the felony of leaving a child unattended in a motor vehicle, unsupervised, and during the course of that crime, Ariya died. That's what makes this a third-degree felony murder, and I stress to you, we're saying not premeditated. And the last element I need to show is that the defendant was a person who actually killed Ariya, and she was. No one left Ariya in the vehicle but the defendant. She's the one who did it. It wasn't like someone else came along and put the child in a car without her knowing. She drove to Stacy's house. She got there. She left her in the car. There's one lesser for that. It's, once again, it goes back to the manslaughter charge, just simple manslaughter. We are not asking for that in this one. We're asking for third-degree felony murder because in this one she was engaged in the commission of leaving a child unattended or unsupervised in a vehicle, and it resulted in Ariya's death. You've all heard in the past 4 or 5 days what happened in this case. But there's some things I want to stress. The defendant in this case failed in her duty as a babysitter, as a nanny. You saw her take the stand yesterday. She actually admitted. These are things, and something that the court had just instructed you on. This is what I'm going through is my memory. Go with your memory. I know some of you have been taking notes. Go with your memory. But this is what I have. She admitted on the stand more than once that she failed in her duty of care. I asked her point blank, wouldn't you agree you failed in your duty of care? And she said yes. She admits it was her responsibility to care for Ariya. She admitted on that day, for those 5 hours, she didn't do that. She admits that Ariya died under her watch. She admits it was her job to watch Ariya. She admits it was her responsibility to care for Ariya on that day. She also admitted it was her fault Ariya was dead. These are things I asked her. And like I said, go with your memory. But these are things she admitted on the stand. These are also things she admitted she didn't do on July 19th. She didn't feed Ariya for those 5 hours. She didn't make baby bottles or baby foods, never changed her diaper, never put baby lotion on her, anything you would do for a baby. She didn't do any of that because Ariya was in the car for 5 hours. Keep in mind that the defendant in this case is a paid babysitter or nanny. This is her job. Brooke and Justice entrusted her to take care of Ariya for those 2 days, every week, whatever it was. They paid her to do this, and she made the decision and said, yes, I'll do this. She did not do this on this day at all. And don't just take my word on it, take her word. She said it yesterday on the stand. She did not do this for those 5 hours. Now let's talk about things she did remember. She remembered picking up Ariya that day. She remembered that Brooke put her in the car. She remembered Brooke putting the baby bag in the car. She remembered going to the Burger King or to the red light in front of the Burger King. She remembered going to Stacy's house. She remembered she got a can of chicken, bag of chips, her cell phone, her drink. She remembered that she texted Brooke twice. She Snapchatted with Nevaeh also. But she doesn't remember Ariya. But she remembers everything else, but not Ariya. The evidence that you heard and what the state has proven is that the defendant went to Brooke's house, Brooke and Justice's house, a little bit before 8. Her job was to get Ariya. That's why she got up that morning, was to watch her and the other kids at Stacy's house. She drives to Brooke's house. Brooke puts Ariya in the car with the baby bag. And the defendant then leaves. And Stacy's house is like 10 minutes, 15 minutes down the road. It isn't that far. But when she was asked yesterday on the stand by me, did you forget Ariya when you were at the Burger King or the light in front of the Burger King? Her response was yes. We're talking about 5-6 minutes. You get up in the morning, you drive to someone's house to pick up their child, and in 4 or 5 minutes you forgot all that? You forgot you got a baby in the back of the car? That doesn't make sense. Then she gets to Stacy's house, she gets out of the vehicle, Ariya is still in the vehicle, but she goes in with everything else in her hand, the cell phone, the chips, and the chicken and all that. But Ariya is still in there, in the car. What was also interesting was when she's inside of the house at 8:17, and you can take this into evidence, the text message, you've all seen it. At 8:17, she texts Brooke, to let her know that Stacy has left. And I asked her yesterday when she was on the stand, didn't that ring a bell? You're talking to Ariya's mom. And she said, no, we talk all the time. And I even said to her something to the effect of, but you're texting her at 8:17 in the morning to let her know Stacy has left. Why else would you be doing that? Unless you had Ariya with you. Then you text her another communication at 8:32 in the morning. Still, nothing went off in her head. Ariya's in the car. She says, I forgot. That doesn't make sense. Then at 11:25, she talks to Nevaeh Carter. That's Ariya's aunt, the young girl that took the stand yesterday. And she's that Snapchat photo responding to it. The point is she's having communication with her. Nothing goes off. But this is something else that's strange. When Brooke comes to pick up Ariya, she knocks on the door, and we know this, there's no answer. She rings the doorbell, there's no answer. She then calls the defendant. And think of it. At that moment, when she calls the defendant, and the defendant says to her, what door are you at? And she says, the front door. She's talking to Ariya's mom. She's talking to her on the phone, hears her voice. It still doesn't go off that Ariya's in the car. This doesn't make sense. And it is only when the door is opened and Brooke walks in, at that moment, the defendant starts screaming, Brooke, Brooke, and runs out. So it didn't go off at 8:17 when she sent a text, 8:32 when she had another text, 11:25 when she talks to Brooke on the phone at around 1 o'clock or 1:15. None of that. It doesn't make sense. We all know what happened after that, unfortunately. EMS is called, Brooke calls 911, they arrive, the sheriff's office arrives, the fire chief arrives. Paul Dickinson took the stand, and he told you they were desperately trying to do CPR. Brooke had called her mother-in-law, Pamela Paige, because she's a nurse for over 30 years, desperate to try to do something to save Ariya. She said that I think the word she used was she felt, I think she said wet and rubbery. Her lips were blue. She's trying to desperately do CPR. Her mother-in-law is telling her, this is what you need to do. Paul Dickinson comes in with his paramedic with him, and they both take over trying to do something. But he even said on the stand, he realized that Ariya was dead already. They noticed that the muscles had stiffened, rigor mortis had set in. The child was already deceased. And they then transferred the child to the hospital. Dr. Aaron Ward took the stand. He confirmed, obviously, that Ariya, unfortunately, was deceased. After he got off the stand, the nurse took the stand, Charles Smith. And Charles Smith said that the temperature was taken of the child. And at that point, and keep in mind, Ariya has been taken out of the car, put in a garage so they can try to do CPR, put in an ambulance, which I assume was probably air conditioned, but put in an ambulance, taken to the emergency room, and I'm sure the emergency room is air conditioned. So some time has passed, but her temperature at that point is 110 degrees. And Nurse Smith said he doesn't remember if the thermometer went over 110. Maybe it did, maybe it didn't, but it was 110 at that point, meaning it could have been higher. And then Dr. Thomas Coyne, the medical examiner, took the stand, and really what we learned from that was he said the cause of death was hyperthermia, over heat of the body, but he also said that when he did the internal exam and the external exam of Ariya, she appeared to him to be a perfectly normal child. He could find nothing except that she had been left in a car for 5 hours. He described what happens when someone is in that situation or an infant is in that situation. He described what happens to a person or infant's body, their organs, their brain swells, what someone would be going through in that situation. The defendant, as you know, was interviewed by investigator Brad Dougherty. I'd like to show you a clip of that if we could.
Sir, I keep way out in the hall. Yes, no problem, sir. You can have a seat out here in the hall inside the hall. I'm taking to her just to take the courage. I know this is very difficult, okay? You just got to get through it, get a statement from you. But because you are here at the sheriff's office, and we're here talking to you in here, I got to still let you know what your rights are, okay? Doesn't mean that you're arrested. Just means you got to know what your rights are because we're talking to you in a place you may not feel free to leave, okay? So, Detective Courage, I'll read this to you.
All right, Mr. Rhonda, you have the right to remain silent. Anything you say can and will be used against you in the court of law. You have the right to talk to a lawyer and have him or her present with you while you're being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you before any questioning. If you wish, you can decide at any time to exercise these rights and not answer any questions or make any statements. Do you understand these rights as I've explained them to you?
Sure.
Okay, with these rights in mind, are you willing to answer some questions for us?
I know this is tough. I know it's very tough. Just kind of walk me through the day and what happened.
I picked her up about 8 o'clock. I usually keep her 2 days a week. So I work Monday at my other job, but some things that fell through, her husband only won't work night shift, so I went back. I went this Wednesday and Thursday at this place where I was at today.
The house where you was at today?
Mm-hmm. So they have twins and a girl that I keep. Anyway, so on the same days, I pick up Ariya from her house, but today was an earlier day because the other lady needed me at 8:15, so I picked her up at 8 o'clock, which is usually 8:30. Anyway, so I picked her up and I pulled through Burger King to get something to eat, but the line was too long, so I left and went to the job I was at.
On the State Street, correct?
Mm-hmm.
Right.
So I got there at 8:15, and the baby was like, because she was asleep, and she was quiet. And because I don't keep her every day, I forgot she was there. So I went inside, got busy with the other kids, and I even talked to the mom throughout the day, and it just didn't click
Right.
that the baby was outside.
So that was at 8 o'clock. What time did you realize the baby was outside?
When I was picked her up,
You know what time roughly that was?
1.
When 911 was called?
Mm-hmm.
Okay. How many kids were in the car when you got home with her, when you got to that house today? Just her?
Just her.
Just her?
Mm-hmm.
And the other kids were there, I'm assuming you babysit them for the family that lives at that house? Is that what they were there, already there? The homeowner that lives there, what's her name? Do you know?
Stacy.
Stacy.
Mm-hmm.
Did Stacy know that you was bringing the other child?
No, because sometimes I have her and sometimes I don't.
Okay, so she had no idea. And where did you park at the driveway?
In the rocks.
In the rocks?
Pulled off into the rocks.
Okay. And the only reason I'm asking, I didn't know if maybe they would have seen anything when they left, when they left there. The stuff that's in the car, the baby stuff, is that for that child?
Yes, sir.
Okay. How long have you babysitted this child?
Since probably June.
Since June of this year? Does he do it every week or every day, or how does that work?
I was keeping her Mondays, with my other job, Monday, Wednesdays, and Thursdays. But she come to me a couple of weeks ago, about a month ago, and said, hey, my mother-in-law's going to keep her on Thursdays, so we'll just have her Mondays and Wednesdays.
Okay.
And so, because I didn't have this other job on Mondays because of their work schedule, I was off on. I kept her on Monday, so I went and got her on Monday, and I've done all my errands in McClenny. And
Sorry.
I keep her till 1, till her mom comes and gets her. So I done all my errands in McClenny, and her mom come and got her at 1 o'clock. That was on Monday, and on Tuesdays I have off. And on Wednesday I went to my other job, and I usually take her with me, but that was on Wednesdays. On Thursdays I didn't have her anymore. On Thursdays her mother-in-law kept her.
So you said, just to go back and reiterate, you said when you got there to the house on the State Street that she was sound asleep. Was the plan to come out and get her a little bit? Or?
No, I normally just get out and get her and take her inside.
But I'm saying you said you noticed that she was asleep when you got there.
Well, I assumed she was asleep. She didn't want to make any noise.
Okay, she wasn't making any noise.
Yeah, I just picked her up. Her mom said that she would probably go to sleep, so I just assumed she had fell asleep, but she didn't make any noise.
This is what's interesting. An investigator, Dougherty, questioned her on it further. And you can listen to that again if you need to. When you're in the jury room, you can come out. We can play it for you again and again. But she mentions to Investigator Dougherty that she got there, I think she says at 8:15, and she says something, the baby was, and then it's inaudible. I can't hear what she's saying. It's hard to make out. But she says the baby was something because she was asleep. She was quiet, and because I don't keep her every day. And then she says, I forgot she was there. And I go inside, I get busy with the other kids. Then she says, I even talked to the mom for a bit. It didn't click that the baby was outside. The investigator, Dougherty, then says to her later, like 3 minutes later, he says, you said you noticed she was asleep? And her response is, I assumed she was asleep. She wasn't making any noise. The mom told me she would probably go to sleep, and she wasn't making any noise. It's like two different stories. There's an inconsistency there. According to the defendant, if you believe what she said yesterday, she forgot Ariya was in the vehicle by the time she got to the light where Burger King is. But my memory is when she was then questioned after I questioned her by defense counsel, it was, I don't remember if it was there or when I got to Stacy's. So in a matter of a minute or two, the story somewhat changed again yesterday when she was on the stand. You've seen this video. Keep in mind that this video, this interview of this defendant was done, I believe, at you can look at the time, I think it's at 2:42 on July 19th, or 2:41. Brooke has testified that she got to the house about 1:15. So it's roughly, I'll say, about an hour and a half later, she's being interviewed. About an hour and a half after realizing Ariya is now dead. You can judge her demeanor on that video, how she appears to you. And I ask you to take that into account. You can judge her demeanor yesterday on the stand, how she appeared to you. And I ask you to take that into account. The body cam footage that we saw yesterday. You can watch that if you want to watch it. You can ask the court. You'd have to come out here. We would play it for you as well. This defendant cared for many things that day. her phone, her trip to England, her kid is going to college, her lunch, her cell phone, but she didn't care for Ariya on that day. She didn't watch Ariya and make sure Ariya was safe. She failed in that duty. Today, we heard from Dr. Brian Cahill. That was the expert that the defense put on the stand. I have a few things I want to say about Dr. Cahill. He talked about this thing called prospective memory error, forgetting to do something. In this case, it would be forgetting that Ariya is in the car. When the court reads to you the jury instructions, you will never see the words prospective memory error. It's not in there. You will never see the words, I forgot. It is not in there. It's not part of the jury instructions. A reasonable person might forget to lock the door when they leave the house. They might go back and check on it and realize, okay, I didn't lock the door. That isn't what we're talking about here. We're talking about a babysitter that left a 10-month-old in a car for over 5 hours. That's what we're talking about here. Dr. Cahill mentioned something. He said 25 is a number he threw out. 25% of parents forget their kids are in the car. That was the number he threw out. He didn't mention, at least from what I heard, unless you heard something different, did they forget their child was in a car for a minute and then remember the child was in the car? Did they forget their child was in a car while they were listening to a song and 3 minutes later they realized the child's in the car? Did they forget their child was in the car for 2 hours, for 3 hours, for 5 hours? He didn't say. Is it just a moment? Is it hours? He didn't elaborate on that. But in this case, once again, we're talking about a babysitter who's being paid. She took the responsibility to care for this child, and she failed, and she admitted that on the stand. Dr. Cahill also talked about being rushed in a routine, that it can affect your memory. This isn't an excuse. Every person has some sort of a routine, and every person probably every day, something comes up you're not expecting, and you're rushed to do it. That doesn't excuse this kind of behavior. He mentioned something called retrieval cue. Something, I guess, to remind you. However, he said the text messages aren't a retrieval cue because they don't mention Ariya in there, even though she's having contact with Brooke, the mother. The Snapchat, he said, isn't a retrieval cue because Ariya is not mentioned in it. But a phone call from Brooke at 1 o'clock, the actual mother calls her, that's not going to be a retrieval cue? I don't know what would be if that isn't going to be one. To the state, the other ones are too. This isn't anyone's fault but the defendant's fault. It isn't Stacy Pascal's fault. The baby it seems was asleep. Obviously, it's not the baby's fault. The baby's sleeping. She had the responsibility to care for this child. She failed in her duty. Just because you forget to do something doesn't mean that you can't and shouldn't be held responsible for it, that you shouldn't be accountable for it. I've given you this example on Monday. And I said, what if you have someone who is driving on the roads? They have a duty of care to be careful for themselves, but also for people who are driving around them. That's their duty when you get behind a wheel. If they're texting and they cause an accident and somebody dies, there's no intent that they wanted that to happen. They can't just say, I'm sorry, I didn't mean for this to happen. They're going to be held responsible and accountable. Something horrific happened. Like in this case, She says, I forgot. She has to be held accountable. She has to be held responsible. Ariya is dead. Ariya is dead forever. She's not coming back because she didn't do her duties that she said she would do. Another thing I mentioned on Monday, I mentioned about, I always call it the school bus puzzle. If some of the pieces of the school bus puzzle weren't in place, would you be able to say it's a school bus? Everyone, I think, said yes, they would, if it was missing a few pieces. This puzzle's a bit unique in that the state feels none of the pieces are missing. I could go through all the evidence that I've mentioned so far, but I'm not going to. But it's the text messages, what happened that day, the doctors, the witnesses, all of that. They're all pieces of a puzzle. But the biggest piece of the puzzle is she took the stand. She actually admitted that she failed in her duty, which makes her guilty of all the offenses. I mentioned to you the judge is going to read you the jury instructions shortly. There's just a couple that I want to point out that I think, well, they're all important, but a couple I'd like to mention. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits and evidence and the instructions that the judge will read to you. This case must not be decided for or against anyone because you feel sorry for anyone or you're angry at anyone. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Look, when you are part of a trial, it is easy to have your emotions affected. We're all human, that can happen. But you were all entrusted as jurors to follow the law. You can't let your emotions decide your verdict. You must decide this case on what the law says and what the facts are. Not how you feel about someone, whether you like someone or hate someone or feel sorry for someone. That isn't what we're here for. And the facts show that she failed in her duties and Ariya is dead because of her. That's what the facts are. And if you follow the law, you would find her guilty on all three counts. I will talk to you again after the defense does their closing. But I'll just end it for now with this. The state has proven this case beyond a reasonable doubt. We're asking you to find the defendant guilty of aggravated manslaughter of a child, Ariya. We're asking you to find the defendant guilty of leaving a child in a vehicle unintended for over 15 minutes because she left her for over 5 hours. And because of finding her guilty of that count, the third count, you have to find her guilty of count 2. Because if someone leaves a child in a vehicle for over 15 minutes and they're dead, count 2, the felony murder, says if you commit a felony and somebody dies, then you're guilty of third-degree felony murder. So the state feels we have proven all 3 counts, and we ask you to find her guilty on all 3 counts. Thank you for your time.
Defense?
Thank you, Your Honor. May it please the court,
You may proceed.
counsel. Brooke, oh my God, Brooke, I forgot the baby. I forgot the baby. I forgot the baby. How could I be so stupid? How could this happen? Those are all words that you all heard that Rhonda Jewell said on this day. This case comes down to whether Rhonda Jewell consciously did an act that led to the death of Ariya Paige. On behalf of myself, my co-counsel, Mr. Nelson, Mr. Badger, and our client, Ms. Jewell, and the state as well, we appreciate your time and your attention to this case. And we offer our condolences to the family of Ariya Paige. This is a tragedy for Ariya, a tragedy for her family, and it's a tragedy for all those who knew her, including Rhonda Jewell, who loved her like her own. This is a hard situation that we have put you all in. It is human nature to want to hold someone responsible for the death of a child that was a bubbly, happy, 10-month-old child who seemed perfectly healthy, and her life was cut short. We acknowledge that, and we understand that, and we understand that we're asking you to do a difficult job. But you have to set aside the emotions of the fact that this case involves the death of that beautiful child. Because as the state told you, the judge is going to read you instructions, and you're going to get a copy of those too, so you don't have to write down every single thing that we say. But the judge is going to read you instructions that say, just as Mr. Yazdia said, this case can't be decided for or against anyone because you feel sorry for them or because you're angry at them. And your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Rather, it has to be based on the evidence, on the law that's contained in the instructions. So your job is to decide what facts have been proven, and in doing so, you have to think about what facts that have not been proven. And you have to take those facts and apply them to the law that the judge gives you and hold the state to its burden of proof in this case. The state has to prove each and every element of these three crimes beyond and to the exclusion of a reasonable doubt. And so the state went through these charges with you. And I'm going to do that a little bit quickly. In doing so, I ask you that if I say things that are not the way you remember them, if I reference facts that you think are not the correct way that they were said, please rely on your memory and not mine, because that's your job, is to figure out what was said and to judge the credibility of this case. So as I said, we've put you in a difficult spot. We are asking you to deal with the circumstances that led to the death of a child. But ladies and gentlemen of the jury, accidents happen, mistakes are made. The question that has to be answered here is whether the mistake in this case rises to the level of culpable negligence. And the court will define for you what culpable negligence is. And so you have to take those facts, as we said, apply the law, and make a decision. And I submit to you, ladies and gentlemen, that although a tragedy occurred, there was a mistake that occurred, and Ariya Paige passed away because of that mistake, a crime was not committed. As I said, the state has to prove culpable negligence related to aggravated manslaughter of a child. So let's talk about that standard of culpable negligence. The state indicated when Mr. Yazdia stood up here, he said that every person has a duty to act reasonably towards others, and if there's a violation of that duty without any conscious intention to harm, that violation is negligence. And that's what's in the jury instructions. But that's negligence. Mere negligence is not enough to convict here. It has to be culpable negligence. And so that definition is something that I'm going to walk through with you and explain why we feel, the defense feels, that the state has failed to prove culpable negligence. So it's not just that someone owed a duty. Mr. Yazdia went through and through the fact that Rhonda Jewell was Ariya Paige's nanny. That is accurate. She had a job. Her job was to care for the child, and that was her duty. But the issue is, did she consciously do something that interfered with that duty? Is there culpable negligence here? So the jury instructions say, again, the defendant cannot be guilty of aggravated manslaughter by causing a death because of a merely negligent act. Culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. We do not have gross and flagrant negligence here. What we have is an accident. Rhonda Jewell forgot the baby. You don't look at the outcome. You don't look at the fact that Ariya is deceased to determine whether negligence is gross and flagrant. You look at what happened. What was the negligent act? The negligent act here was that the baby was forgotten in the car. Forgotten, not consciously done, not culpable negligence. Obviously, the outcome here was a horrible tragedy. And the state keeps talking about the fact that Ariya was left in the car for 5.5 hours. It's important to remember that the medical examiner, Dr. Coyne, indicated that it was likely that Ariya died within 20 to 30 minutes inside the car. Still horrible, still a tragedy, but it's something important to remember. And it's horrible no matter how long it took to occur. But again, you don't look at the outcome to determine whether the negligent act was gross and flagrant. You look at the act itself. Looking at the conduct itself, the conduct on the part of Rhonda was not a conscious decision, not a conscious act, not something done on purpose. The jury instruction goes on to say that culpable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want or lack of care as to raise a presumption of a conscious indifference to consequences. Conscious indifference to consequences. You all saw that body cam footage of when the officer arrived and walked into that garage. You saw Brooke Paige walk out and how upset she was. And right behind her was Rhonda Jewell, and she was just as upset as Brooke Paige. Was that the face of someone exhibiting a conscious indifference to human life, or a conscious reckless disregard of human life? I submit to you that it was not. Jury instructions go on to say, the negligent act or omission, again, must have been committed with an utter disregard for the safety of others. There was no conscious act done here. It was simply she forgot the baby. Culpable negligence under the jury instruction says that is consciously doing an act or consciously following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. People know that you can't leave people or children in cars, that can reasonably lead to injury. But again, here, there is no conscious act on the part of Rhonda Jewell. She forgot the baby. Rather, what we have here is a tragic accident. There was no conscious choice on the part of Rhonda Jewell to leave Ariya in the vehicle. The state seems to suggest that they just want you to ignore that part about culpable negligence and just say, well, there was a duty here. She didn't complete the duty. The baby passed away. That's it. That's all we have to prove. But again, that's not what the law says. And you all promised to follow the law even if you didn't like it. And I know, again, we put you in a tough situation because human nature is you want to hold someone accountable. But this is not a crime. The state has failed to prove that a crime occurred. The state has failed to prove anything more than Rhonda forgot this baby in the car. There is no evidence that has been presented that indicates anything other than the fact that she forgot. And ladies and gentlemen, accidents happen, and sometimes they have tragic consequences. The state keeps saying, well, she remembered picking Ariya up from Brooke. She remembered this, she remembered that. It doesn't make sense. Does it make sense that the text messages didn't trigger her? It doesn't make sense. Does it make sense? Ladies and gentlemen, the only way any of this makes sense is that Rhonda forgot that baby. You heard from Stacey Pascal. She thoroughly vetted Rhonda before she hired her. She talked to people she worked with. They told her, if there is any babysitter that you want, Rhonda's the one. Brooke Paige and Justice Paige knew Rhonda. They were tight, close friends. They had known her for years. They had seen her interact with the other kids that she nannied. They had seen her interact with Ariya. They trusted her with Ariya because she had never given them any reason to doubt the care that she would provide. So the only way that this makes sense is that she forgot the child. If the text message had triggered her memory, she would have gone and gotten Ariya out of the car. And I wish that had happened because we wouldn't be here today. But it didn't because she forgot. As we said, culpable negligence is consciously doing an act or following a course of conduct. The only course of conduct that you have heard today is that Rhonda was a good babysitter and exercised great care for the children that she took care of. She engaged with them, she played with them, she got down on the floor in their level and had a good time with them. She wasn't one of those babysitters who sat on her phone all of the time and let them just run and play. That's not what's been testified here today, too. Now, the jury instructions also say that neglect or negligence can be caused by a single incident or repeated conduct. But remember, the state doesn't just have to show neglect, they have to show culpable neglect. And in every one of those lesser includeds, and you're going to get a verdict sheet, in every one of these lesser includeds, the state, to prove any of those, has to prove culpable negligence. And I submit to you, they have not. And that culpable negligence is defined the same way across the course of all of those charges. Now, the state seems to suggest, as we've said, that this doesn't make sense. It doesn't make sense. It doesn't make sense. I'm not sure if the state is trying to imply that Rhonda left the baby in the car on purpose, which I would submit to you makes absolutely no sense. You heard her testimony on the screen that she usually picked the baby up immediately and walked in the house with her. There was no evidence that she would leave the baby in the car if the baby was asleep and go back and get her later on a repeated basis. That was not presented to you. So I'm not quite sure where the state is going with this. It doesn't make sense. Because again, the only way that it makes sense is that she forgot her. And what are the factors that show that that Rhonda truly forgot this baby? What actually triggered Rhonda to remember that Ariya was in the car? I submit to you that based on what Rhonda testified to, it was the money that was in Brooke's hand. When Brooke walked in that door with the money in her hand, Rhonda remembered that she was supposed to have had the baby that day. And at that point, she shoves Brooke to the side, takes off running to that car, screaming Brooke's name over and over again. Screaming her name, urinating on herself as she runs, to that car to get the baby out just as quickly as she can. She is so frantic that when Brooke asked her to call 911, she had to go back and find her phone and couldn't remember the code to get into the phone. Ladies and gentlemen, you can't fake those kinds of responses. She had forgotten Ariya. She had forgotten that she had her. Further, she repeatedly told Stacy as she called her, or told her when she called her, I forgot the baby. But Stacy Pascal testified to you guys that she was so upset that she was screaming and crying and so distraught that she could barely understand what she was saying, and she had to ask her to repeat herself. And all Rhonda could say was, I forgot the baby, come home. And you also have the testimony from Stacy saying that when she got home and made it to Rhonda, Rhonda physically got sick and vomited and was dry heaving in the bushes. You can't fake those. Those are all indicators that Rhonda truly forgot this baby was in the car. Now, we heard from Dr. Cahill today, and he talked about memory. We all know that people forget things. We've all done it. And he named that failure to remember things that you're supposed to do in the future as prospective memory error, meaning you forgot to do what you were supposed to do in the future. And he talked about the fact that there were several things in our lives that can contribute to those kind of errors. Multitasking, divided attention, stress, rushing, lack of retrieval cues, and sleep. I think I got them all. And the only one that he said that was not present in this case was sleep issues. Every other one of those factors was involved. And one of those factors, any one of them by themselves, can affect your ability to remember things. But when you start piling them on top of one another, it greatly increases the likelihood that you're going to have a prospective memory error. Now, the state may say, well, you can remember everything else, but you forgot the baby. Well, that's the only answer that makes sense. Because we know that when we forget to do things in our lives, we don't forget other things. If we forget to stop and get something at the store, we don't forget how to drive. There's not a total amnesia there. That's the way the brain works. It's a prospective memory error. And the state wants to make a big deal about Rhonda saying maybe she forgot the baby at the Burger King. That's when she had forgotten that she was there. Or maybe it was when she got to Stacy's. I submit to you, think back to the questions that the state was asking Rhonda yesterday on the stand and how they were asking the questions. They were pressuring her. They were rushing her. And I submit to you, she doesn't know at what point she lost awareness of the baby or forgot the baby. If she knew that, she would have remembered the baby. The state wants to say that there's no way you can forget a child within this 15-minute period or window. And generally, Dr. Cahill said, the longer or the shorter the period of retrieval, the better chance you have of remembering it, as opposed to if it's a longer period, if everything else is equal. But in this situation, we've got habit changes that are going on. We've got Rhonda arriving at Brooke's house earlier than usual. She's pressured to be at Stacy's house on time. She wants to make sure she's on time. It's not holding her up. You have the other things that are going on in her life and the other stress events. And yes, everyone has stress. This was an unusual amount of stress for her because there were big things that were happening in her family. And you heard Rhonda say, that's not an excuse. That's not an excuse. And it's not an excuse, but it does explain to you why prospective memory errors happen. It explains to you why Rhonda forgot. You've got this multitude of, I'm rushing, I've got to be here earlier than usual, I'm multitasking, I'm already thinking ahead as I'm driving about my day, or rather Rhonda's thinking ahead as she's driving about her day. She's thinking, hey, I'm going to have the twins and big sister. I should stop and get them breakfast. Oh, let me look at Burger King. The line is too long. She doesn't have time to do that. So she's distracted by all of these things, and she's planning ahead and trying to keep all of the balls in the air that she's juggling. And somewhere within that drive, she forgets that Ariya is in the car. It's clear from the testimony, both yesterday and from the video, that Ariya was not making noise. She was quiet in the car. So Ariya's not making any noise to make herself known, to trigger Rhonda that Ariya's back there. The lack of retrieval cues is important, and the multitasking and divided attention is important because not only is it happening in the car before Rhonda gets to Stacy's, those things continue to happen as the day progresses. So in the car, we just described, Rhonda's thinking about breakfast and getting to Stacy's on time and all of those things. All of Ariya's belongings are in the back floorboard of this car. Her baby blanket is in the car seat with her. She is rear facing. Brooke testified that she's the person who put Ariya in the car. She put the baby bag in the floor of the car. I submit to you that the lack of hands-on putting in the car by Rhonda Jewell suggests that she would need a stronger retrieval cue to remember the baby. And there's nothing up front. The state's probably going to try to make a big deal about the fact, well, Rhonda remembered her cell phone, she remembered her lunch, and she remembered her cup, and she took that in the house with her. All of those items were in the console area, generally immediately in her point of view and within reach. And she grabbed those things and got out of the car. Everything related to Ariya is in the back seat, and Ariya is quiet. Lack of retrieval cues. Then when she gets inside, she's immediately taking care of 3 other children. She's playing with them. She's watching things on her phone. She's engaging with them. She's cooking them breakfast. She's cooking them lunch. And there's nothing of Ariya's inside the house. Nothing to remind her of Ariya. The state brings up the text messages and says, well, these should have been retrieval cues. Well, Dr. Cahill gave you an example of that. And he said, well, if Brooke and Rhonda only had this relationship of babysitter, employee, and employer, yes, the text message might have been enough to trigger Rhonda's memory and make her remember that she has forgotten Ariya in the car. But that's not what we have here. These families were tight. They spent dinners together. They spent vacations and big events together. Rhonda and Brooke Paige texted or talked on a daily basis. And Rhonda did the same with Nevaeh Carter. They were like her family. They communicated on a daily basis about things far different and far separate from Ariya. And you've seen the content of those text messages just left. And that was a continuation of a conversation that had started before that, in which Rhonda had been talking to Brooke, her friend, about her frustration sometimes with Stacy asking her to come early and then Stacy Paschal not leaving whenever she asked her to do so. Nothing in those text messages mentions Ariya. There's no asking about Ariya. Nothing in the conversation would trigger Rhonda to remember Ariya because of that close relationship that they had and the fact that they communicated all the time. That's what Dr. Cahill was trying to say today. Also important to remember is the change in routine. So clearly Rhonda started keeping Stacy Paschal's twins in, I think, March, April of 2023. Again, if you remember that date, that time frame differently, rely on your memory. She's keeping the boys 3-4 days a week. Fast forward to May, early June, Rhonda then starts to keep Ariya. And at that point, she's keeping the twins and Ariya on Mondays, Wednesdays, and Thursdays. Fast forward 2 to 4 weeks from that, and the schedule has changed again. So we are now maybe middle of June, early July, and Ariya is now coming back, and the days are backing down. Her grandmother's going to keep her on Thursdays. So Rhonda has Ariya and the twins on Monday and Wednesday, and then has the twins by themselves on Thursday. And every time she has the twins and Ariya at the same time, they're going to Stacy's house. But there are times when she doesn't have Ariya, like Thursdays, so she only has the twins at that house. And then you heard in the couple of weeks leading up to July 19th, specifically if you backtrack to Monday the 17th, Rhonda didn't have the twins. The schedule had changed again. The twins' dad was now working night shift, and so they had backed her down to Wednesdays and Thursdays. So you've got Ariya with Rhonda on Mondays, not at Stacy's house, and they're running errands. You've got Ariya on Thursdays, Rhonda on Thursdays, just keeping the twins. And then I think even if you back it up, so you've got the 19th when this unfortunate incident happened. You've got a schedule change on that day with we got to be early. The Monday before that, there's a schedule change. It's just Ariya. The Wednesday before that, it was testified that there was a schedule change and it was just Ariya. And that Thursday before would have been just the twins. So you have all of these changes going on in a short period of time, in addition on top of all of these other factors. And again, multitasking divided attention by itself could lead to prospective memory errors. Lack of retrieval cues by itself can lead to errors. Changes in the routine can lead to errors. But when you put all of those together, you've got a perfect storm, and a more likely than not, an even greater likelihood of this prospective memory error. Now, one of the things that you heard Dr. Cahill say is that when people look at things and stuff happens, we as people are more likely to attribute negative character traits to something somebody else does to us than to consider those negative character traits as opposed to environmental factors. Like you gave the example, you're driving and someone cuts you off. Your immediate reaction is to think, oh, that person's a jerk. You're not going to give them any benefit of the doubt. But if you had cut someone off, then you're more likely to think, what's going on here? I've got to get to the hospital. I'm in a hurry, such and such and such and such. So the reason that's important is because people in general, I think Dr. Cahill said or testified to, they question, Miss Johnson, how can you forget a baby in a car? A baby is not a gallon of milk at the store. It's a super important thing. But that brings up the conversation that Dr. Cahill had with you. Prospective memory errors lead sometimes to catastrophic results. He told you about the study with the airplane crashes. I think he said 74 out of 75 airplane crashes were related to prospective memory errors. Just because it's something really important doesn't mean that your brain won't forget it. It doesn't mean that you can't forget. And Dr. Cahill was honest. He said, I can't say definitely that Rhonda Jewell had a prospective memory error or not. I'm not in her brain. But what he did tell you was that all of those factors that we just got through talking about make it more likely than not that she would have had a prospective memory error, and that those factors support what she told you, which was that she forgot the baby. And how do we know that the error actually occurred? Because she didn't get the baby out of the car. Had she remembered Ariya, she would have grabbed the car seat, taken her inside, and played with her and loved on her all day long. She was a good nanny, and she loved Ariya. So again, you might think about, Miss Johnson, how do we forget a baby? You heard Dr. Coyne, the medical examiner, say he's dealt with about 4 hot car deaths over the course of his career. So they're not super common, but they do happen. Even Brad Doherty, on the video interview of Miss Jewell, says it's possible to forget things, even a child. It's possible to forget things, even a child. And Dr. Coyne also testified that even though he's only had 4, that he's had to deal with post-death investigations, autopsies related to in his career, he said they still happen every summer. And he also said that they can happen even in milder conditions when the temperature is not the middle of July. And I submit to you that if this were not a more common occurrence, if it were not a problem, the new cars that you buy wouldn't have those car sensors in them that say, check the rear seats when you get out of the car. They don't put those things in vehicles because one child dies. It happens. It's a tragedy. But Rhonda forgot the baby in her car. It is not a crime. When you look at counts 2 and 3 in this situation, count 3 is the charge of leaving a child unattended or unsupervised in a motor vehicle causing great bodily harm. And that requires the state to prove that Rhonda Jewell was a person responsible for Ariya. Ariya was less than 6 years of age. And Rhonda Jewell left Ariya Paige in the car for a period of more than 15 minutes. Rhonda didn't leave that child there. She forgot the child. Leaving implies that you intend to come back. Rhonda forgot the baby. And I submit to you, and as the state I think has indicated, that if you don't believe the state has proven count 3, that she left the baby, which she didn't because it was an accident, she forgot, then you can't find Rhonda guilty of count 2, the 3rd-degree murder. Now, the state seemed to suggest that if you found her guilty of count 3, you had to find her guilty of count 2. That's not what the jury instructions will tell you. They will tell you that you have to analyze 3 first, and only if you think that there's been proven beyond a reasonable doubt on 3 do you even get to 2. But then you still have to weigh that situation independently. Now, as we've stated multiple times, it's your job to weigh the evidence and determine what has been proven beyond a reasonable doubt. And the court's going to instruct you about what reasonable doubt is, and it's some of what it will say is that a reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. I submit to you, ladies and gentlemen, that there is a lack of evidence in this case to prove that Rhonda Jewell did a conscious act. She didn't do anything on purpose. She forgot the baby. And it's your job to hold the state to that burden of proof and require them to prove the culpable negligence. It's not just mere negligence. It's culpable negligence, which is a much higher standard that we have talked about ad nauseum now, so I'm not going back through that again. The state brought up their school bus picture. And the state says, well, if I give you most of this picture, you can figure out it's a school bus. You should still be able to find guilt beyond a reasonable doubt, even if parts of this puzzle are missing. Ladies and gentlemen of the jury, the state has failed to prove that a crime occurred. They failed to prove the meat of the situation, which is that there was culpable negligence. The whole school bus is missing. There's not proof beyond a reasonable doubt here. The other thing that the state says doesn't make sense is this phone call with Brooke at the door. So Brooke said she knocked. Nobody came. I think Rhonda Jewell explained. We were in the kitchen singing, never heard a knock on the door. Brooke tried to use the doorbell. Stacey Pascal says doorbell didn't work. And then Brooke calls. The state tries to make this seem as though it's suspicious or something's going on. There's nothing going on except for Rhonda is taking care of the twins that are in the house and doing what she's supposed to be doing related to them and feeding them and doing those things. And they're having a good time and they're singing, right? There's nothing suspicious going on there. And then the other trigger that makes you know that Rhonda forgot is that when Brooke called her, she's asking Brooke, where are you? What door are you at? Something to that effect. And you saw Rhonda Jewell yesterday. She testified about that, and she was like, I was confused. Like, why are you here? What's going on? That phone call still did not trigger her that she had Ariya. And again, it goes back to the fact that they talked all the time. So when Brooke is saying, I'm here, that's why she's like, where are you? What door are you at? She's confused. It's not until she sees the money in her hand, that is usually payment for her services, that she remembered that she had Ariya. May I have just a moment? Ladies and gentlemen, I'm going to play a portion of Rhonda's interview with Brad Doherty again, and Mr. Nelson's going to help me set that up. And I'm actually going to try to put these speakers closer to you, because you heard Mr. Yazdia say that there was a portion of this interview that is not, you can't hear it, that is unintelligible. I submit to you that you can, because what the state's trying to do is they're trying to say that in this interview that Rhonda says she was asleep. They're trying to use that to make you guys believe that Rhonda knew the baby was asleep and that that's why she left her in the car. They haven't flat out said that, but I think that's where they're going. And I submit to you that that's
Your
not
Honor,
what
the
she
state
said.
objects to the characterization of what she thinks I'm trying to do.
Sustain.
Sorry. I believe that the evidence, the state may portray the evidence as though that the baby was asleep and that that's why Rhonda left the baby in the car. I submit to you that that is not what this recording says, and so I'm going to replay it. If we could start at 2 minutes and 32 seconds. Detective Doherty said that Rhonda said that the baby was sleeping in the car, but that's not what she said. And so I'm going to play this for you. And remember, you can watch this video again if you need to. I'm going to fast forward to 2 minutes and 32 seconds. We're at 2 minutes and 24 seconds, assuming the computer does what it's supposed to do. It helps if we plug it in.
Too long, so I went to the job I was at on the stage. So I got there at 8:15, and the baby was not. She was asleep and she was quiet.
She says, I got there at 8:15. The baby was, I guess she was asleep. She was quiet. And again, if you heard something different, I rely on your memory. And then she says, because I don't keep her every day, I forgot she was there. So it's not that she's saying the baby was asleep, so I purposefully left her in the car. She's saying, I guess she was asleep. She was quiet. Now, the state talked about Rhonda's demeanor as she talked to you today, and her demeanor in this interview. You've also had an opportunity to hear about her demeanor from Stacey Pascal. You had the opportunity to hear from her demeanor about Brad Doherty. You had the opportunity to briefly see her on that body cam footage as she's coming out of the garage as the officer is going in. Clearly, from those accounts, Rhonda Jewell was distraught, very upset. Stacey indicated that she vomited, that she was dry heaving, that she was screaming and so distraught that she could barely understand her. And in the course of that, she had urinated on herself. This interview happens an hour and a half later, and Detective Doherty says that Miss Jewell has significantly calmed down by that point. But you can still hear and see the emotion on her and in her voice as she talks. And you could see and hear it yesterday. So please take into consideration all of those things when you're thinking about her demeanor, for whatever her demeanor is worth to you. But I submit to you that her demeanor is that of a person who forgot a child in a car. She forgot the child. She didn't think the baby was sleeping and leave there. When you fast forward in that interview and the part that the state played earlier, Brad Doherty circles back around to Rhonda and asks her, and she says, I assume she was sleeping. You heard Dr. Cahill testify today that the fact that Miss Jewell remembers all of the other time frames and things that are going on this day, but didn't remember Ariya, doesn't make her memory bad. It doesn't make her be untruthful. What happens is she's had to recount this story to multiple people, attorneys, the sheriff's office, friends, family, through this last year and a half since this case happened. And you also heard her words. I forgot the baby. I forgot the baby. How could this have happened? I submit to you that she spent the last hour and a half before this video interview going through her head, how could this have happened? How could this have happened? So when she says, I assume she was sleeping, she wasn't making noise, she's not saying, oh yeah, I left her in the car because she was asleep. She's saying, I forgot she was there and she was quiet and That's part of why I forgot that she was there. Again, I submit to you that that's not an inconsistency as the way the state would want to say it is. Rather, it's a person being interviewed an hour and a half after an extremely emotional event that was tragic to her, the death of a child that she loved. The state is correct when it says that in these jury instructions you will never see the word prospective memory. You'll never see, did she forget? Prospective memory is just a fancy way of saying that you have to remember something in the future. And a prospective memory error is just saying that you forgot to do that. You forgot to remember the thing that you were supposed to remember to do in the future. Again, what these jury instructions say is that the state has to prove that Rhonda Jewell did a conscious act or consciously chose to follow a course of conduct that she knew or should have known was likely to cause death. I forgot does not mean a conscious choice. It means I forgot. There was no conscious choice that was made. And the state didn't call any doctor to refute Dr. Cahill's testimony.
Objection, Your Honor. If we can approach briefly.
You may.
The state brought up the example of a driver's duty of care, and that you all agreed that a driver has the duty to exercise care to both themselves and to the other public surrounding. And he brought up the fact that if the driver's texting and causes an accident, the driver should be held responsible for what they did. This driving example is not in any way related or akin to what we have here. If a person is driving and chooses to text, that's a conscious choice. They have consciously chosen to violate whatever duty of care there is there. And then again, the jury would have to decide, was that culpable negligence? In this situation, again, there was no conscious choice. Just like going back to those lifeguard examples that the state used in jury selection. And the state was talking again about the duty of care, and violating that was negligence. Well, again, I think the examples that were used were the lifeguard falling asleep, or the lifeguard, reading a book or being otherwise distracted and not doing their job. This, again, is not that case. In that situation, the lifeguard was consciously doing something or making a choice, whereas in our situation, that is not the case with Rhonda Jewell. And B, again, even in that situation, if you went back to the lifeguard, you have to look at whether it's culpable negligence. Again, the results do not determine whether culpable negligence occurred. You have to look at the negligent act itself and determine whether that was a consciously done act or a consciously chosen course of conduct. And I submit to you that it was not. This was a mistake. This was an error. It was a memory error that Dr. Cahill said could happen to anyone, and does. These sorts of memory errors, the failure to remember to do something in the future, does happen to anyone. And unfortunately, sometimes those results are catastrophic. This is a tragedy. It is a horribly sad situation, but it is not a crime. Again, it's human nature to want to hold someone accountable, but you have to apply the facts that have been proven to the law that is given in making your decision. And the defense submits that after you do that, that the state will have failed to prove culpable negligence beyond a reasonable doubt, will have failed to prove that Rhonda Jewell made a conscious act or decision to leave Ariya in the car, and that this was simply a horrible mistake, a horrible lapse of memory. And so we are asking you to find her not guilty on count 1. We're also asking you to find her not guilty on count 3, because she did not leave the child in the car, she forgot the child in the car. And as such, you can't find her guilty of count 2, the murder that is predicated on count 2. Again, I thank you for your time, and we appreciate you. Thank you.
May it please the court, Your Honor?
You may proceed. Yes, sir.
Thank you, Judge. The defense kept on saying this is an accident and this is a mistake. Brooke in Justice on July 19th gave a perfectly healthy baby, Ariya, to this defendant to care for, who made an agreement that she would care for her. 5 hours later, Ariya is dead. This isn't a mistake. It isn't an accident. I had mentioned before that you will not see the word forget or I forgot or prospective memory error in the jury instructions, and you won't. The defense keeps on saying she forgot. As I said before, and I'll say it again, there are still consequences for your actions. One should still be held responsible. This defendant should still be held responsible for the death of Ariya. Ariya was in her care. The baby died. It's plain and simple. I was listening to what the defense was saying, writing notes. Once again, go with your notes. But it seems everyone is responsible for the death of Ariya but the defendant. So let's go through this. One of the things I heard was Ariya wasn't making noises to trigger the defendant's memory. So I guess it's Ariya's fault that she didn't make noises. Next, Brooke's fault. She put the baby bag and Ariya in the back of the seat. I guess Brooke could have put the baby in the front seat or the baby bag in the front seat. So we'll blame Brooke for the baby's death. Next, we talk about multitasking, that the defendant had so many things going on. One child's going to college, they're going to England, she's got all these things going on, so we're going to blame multitasking as the third reason as to why Ariya is dead. Next, it seems to be my fault. I pressured her when I was asking her questions yesterday. And so as she was admitting to things, it suggested that I pressured her to answer them that way. So I guess it's my fault at this point. Next, we talk about a change in routine, because it wasn't normal that she would pick Ariya up on that day or Stacy's kids on that day. So we're going to say it's a change in routine. That's why Ariya is dead. I could go down the list of reasons that were given. There is one reason why Ariya is dead, because she failed in her duty to care for her. Call it a mistake. It isn't a mistake. Say she forgot. That doesn't justify what she did. It isn't an excuse for what she did. Ariya is dead because of...
May we approach?
we keep on talking about the word culpable negligence. I'm going to read part of it again. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause the death of the victim in this case. This defendant engaged in a course of conduct that she should have known would cause the death of Ariya. It's that plain and simple. And as I said last time, every person has the duty to act reasonably towards others. If they violate that duty without a conscious intent to harm, there's still negligence. They still violated it. So it's a course of conduct or consciously doing something. I don't have to show both.
Your Honor, objection. May we approach again?
No. Sit down, please. Have a seat. You can make your argument from there. What is your argument?
My argument is that the state's mischaracterizing the law and discussing negligence instead of explaining culpable negligence to the jury.
Your response?
I am actually reading, Your Honor, from
The instructions.
definitions that are part of the jury instructions.
I think the problem is he's not giving the entire context of that sentence, Your Honor.
Okay, the jury will note that he's only reading a portion of the definition. I will read the entire definition to you, and you will have that definition later. But he's making a point, apparently, with respect to that. Carry on, sir.
Thank you, Your Honor. Defense had mentioned about gross and flagrant. That is also part of the definition of culpable negligence. If the death of a 10-month-old child who's been left in a vehicle for 5 hours isn't gross and flagrant, the state doesn't know what would be considered gross and flagrant. This is gross and flagrant. This shows a reckless disregard of human life. Also part of the definition of culpable negligence that the court will read to you. It must be gross and flagrant. It must show a reckless disregard of human life and for the safety of other people, including Ariya's safety. That's part of the definition of culpable negligence. The court will read to you the entire definition and listen to the entire thing because it fits. What the defendant did is completely culpable negligence. It satisfies count one completely. Something else that the defense mentioned. The defense mentioned the child probably died in 20 or 30 minutes. The child is dead. Whether the child died in 20 or 30 minutes or 4 hours, Ariya is dead. Does it make it better that it's in 20 or 30 minutes? Does that somehow excuse this behavior? Ariya was in a hot car. What we know is her temperature went up to at least 133 degrees because the car went up to 133 degrees. Her brain was swelling, her organs stopped working, and she died. Whether it's 20 or 30 minutes, or 1 hour, or 2 hours, or 5 hours, the point is Ariya is dead. The course of conduct, some of the things that we can point to is the defendant had a duty here. The defendant drove to Brooke's house. The defendant was present when Brooke put Ariya in there, in the baby bag in the car. There is a course of conduct here. The defendant then went to Burger King and decided to leave. Her next course of conduct was to go to Stacy's house. Her next conduct was to get out of the car with all these items, except for the baby. There is a course of conduct here where she knew or should have known that Ariya was in the car. Something else that the defense mentioned about the defendant remembered when Brooke was at the door and had money in her hand. Please go with your memory. The defendant said Brooke had money in her hand. The state doesn't remember Brooke ever saying anything like that. Go with your memory, but the state does not remember Brooke testifying to that. Defense also mentioned about the defendant urinating on herself, vomiting. There could be a lot of reasons for that. One of them is because a child was in her care and the child is now dead. Forgetting a child in a car is not a defense or an excuse for this. Saying it's an accident or accidents happen. I am sorry. I promised you I would take care of your child, and I forgot. Child's dead. It doesn't work that way. There are repercussions for something that drastic when something like that happens. Defense mentioned a few times that the defendant and the victim's family, I believe, were very close. That has nothing to do with this case. Has nothing to do with this case. Has nothing to do with July 19th. The fact is, yeah, I guess they knew the defendant. But she didn't care for Ariya, meaning she didn't take care of her on July 19th. I said, and the defense agreed with me on this, you will never see prospective memory error on the jury instructions. It's not there. You are still held responsible, and there are still consequences. The defense mentioned, and I'm going to repeat it, that Dr. Cahill says he doesn't even know if the defendant suffered from prospective memory error. He can't even say that she had this. He has no clue. He's just telling you what it is. She may not even have suffered from this thing called prospective memory error, which is a fancy way of saying people forget things. The defense mentioned she didn't, this is semantics. The defense said she didn't leave the child in the car. She forgot the child in the car. Look, count 3 is very clear. I don't need to prove intent. And the state has made it very clear. On count 1, we're saying culpable negligence. We're not saying intent. I don't need to prove she intended to do anything. Count 2, I was very specific to say 3rd-degree felony murder, not premeditated. And what the state means by that is we're not saying she meant to do it. We're not saying she intended to do it. And then count 3, the same thing. I don't need to prove any intent, and I've never alleged she intended to do it. But we're not going to play word games here and say leaving is not the same as forgetting. She didn't leave the child in the car for 5 hours. She forgot the child in the car for 5 hours. The statute is clear. If you leave a child in a car for 5 hours, unsupervised, over 15 minutes, and something bad happens, you're guilty. She left the child in a car. I'll just very briefly say that defense had talked about her demeanor on the video. I'm going to ask you to judge her demeanor. It's been an hour and a half, which to the state that isn't a lot of time. An hour and a half later, she's giving an interview. You judge her demeanor. An hour and a half after she realized that a child in her care is now dead. Prospective memory error. Do you need to remember to care for a child when you pick them up from the parent's house? Ms. Johnson mentioned about my driving example, that you make a conscious decision to drive. She made a conscious decision to care for Ariya. She was getting paid money. She picked her up on certain days. She drove there that day. She had Ariya put in the car, the baby bag put in the car. She made a decision to care for Ariya on that day, and she didn't. Once again, when you go back into that jury room, look at all the evidence. I've put some evidence on, the defense has put some evidence on. You as jurors have to look at everything, not just the state's evidence, the defense evidence as well. We are asking you for count 1 to find her guilty of aggravated manslaughter of a child. Ariya is dead because of her culpable negligence. Then for count 3, I like to switch it, leaving the child in a car for over 15 minutes, resulting in death. She's guilty of it. And once again, we're not saying she did this on purpose. That doesn't matter here. We're not arguing intent. And then for number 2, 3rd degree felony murder, not premeditated, because the felony she committed was leaving the child in the car for over 15 minutes, 5 hours actually, and the child died because of her actions or inactions for not caring for that child. So once again, I ask you to find her guilty on all 3 counts. Thank you.
Members of the jury, we have some rather lengthy jury instructions that I'm going to have to read to you. So before we do that, we're going to go ahead and take about a 15-minute recess so you can stand up, stretch, and be ready for the instructions. So we are in recess.